Good afternoon, everyone. So, today we have a rapid revision session on Limitation Act of 1963. Am I audible to everyone? Yes. Am I audible to everyone? Am I audible to everyone? Good afternoon. Yes. Okay. Okay. Vikas, am I audible to you? Yes, Vikas. Is my audio and visibility clear to everyone? I'll just check it. Fine. So today we have a rapid revision session on Limitation Act. So for DJS. So hope you all have already gone through the act. We are just going to do a rapid revision session on this act today. So before I can start, I would like to present one thing. Wait. Yes. Is my screen visible to everyone? Students, is my screen visible? Right. So now, students, first you all see that what are the important sections and article for Limitation Act, since you people are going to appear for DJs and it's very near. So these 12 sections I have jotted down as very, very important. See, Limitation Act is a very small act, right? But as a small it is very important also. It plays a very important role. So in DJS also, many questions come from limitation, and you will surely get something from here, from these sections. I will be starting the act shortly, but before, let me just give you all this important sections and articles for Limitation Act. So these are the 12 sections which are very important, right? Section 3, section 4, 5, 6. So 3, 4, 5, 6. Section 9, 12, 14, 15, 18, 19, 21, and 25. The most important sections. See, every section has an equal weightage, and all topics have an equal weightage, but depends on your luck. Still, we can tentatively predict some important sections which might come. Okay, so this 12 sections are very important, don't miss them. 3, 4, 5, 6, 9, 12, 14, 15, 18, 19, 21, and 25. होप आप लोगों ने ये नोट डाउन कर लिया है. It's blurring. Is it blurring for everyone, students? Is it okay now? Is it still blurring, students? If it is, I'll just. Is it okay now? Right. So these are the important section. Don't miss them. These 12 sections. Now, apart from section, you will see that Limitation Act also has a part which contains article, right? So you will see that Limitation Act, you have the schedule where period of limitations are given. So among that, I have just filtered out some important articles, if this articles are visible to everyone, right? So some articles are really important. Now the ones which I have marked in green, right? Now those articles are one which I'll come to it. It is not 3 years; they are different from 3 years. So mainly, if you see, if you have, if you know the trick of learning this 137 articles, right? How many articles are there in the schedule of limitation act? There are 137 articles. So if you want to know the trick, that too I'll tell you. Now the green, the ones which are marked green are having a period of limitation of 12, 30, 2 years kind of, or days. They must be in days, and that is why I have marked them green. The ones which are not marked, that means their period of limitation is 3 years only. So it's article 42, article 54, 59, 60, 63, 64, 65, 75, 76, 78. Okay, 93, 96, 97. Please write this down. Okay, 102, 105, 107, 109, 110. Okay, then 112, 115, 116, 118, 120. And then we have 121, 122, 123, 127, 130, and 133, 135 and 137 also. So 137 is the last article of the schedule. Hope everyone has noted it down. Any issue, students? Everything is marked. Everything is marked from here. Any issue, students? Everything is marked. Everything is marked from here. Any issue, students? Yes. So now you see that I have again, marked this part, where this is the note part, where I have marked down part 5 of the schedule, right? Part 5 of the schedule, if you see, it's from section 61 to 67, except 61 clause C. 61 to 67, you will see this article, not section. Okay, it will be article. Article 61 to 67, you will see that they have a period of limitation of 12 years or 30 years, right? So please, you all mark it differently. See, most of the articles have 3 year limitation period. The period of limitation is 3 years, but some have 12 years, some also have 30 years, some have 2 years also, 1 year also, and days also, right? So these are the part which are not 3 years. Apart from this, any question comes regarding period of limitation, mark it 3 years. But for this, just remember it, that these are the portions which are not 3 years. These are must be either 12, 30, 1, 2, or days, right? So if you see 61 to 67, except 61 clause C, you will see it's 12 years or 30 years. Section 92, 94, 96, 106 to 110, these are all 12 years. For 30 years, you will see it's 61 clause, C, 63 clause A, 101, 112, you will see they have 30 years as limitation period. देन पार्ट 6, इफ यू सी, पार्ट 6 में आप देखो, देखना कि सेक्शन 72 to 84, section 97, and section 100, okay, they all have 1 year limitation period, except section 82, 83, and 84. Some have 2 years also, right? So just check that in your bare act, which is 1 year, which is 2 year. 82, 83, 84 are all 2 years. Okay, these are 2 years, having 2 year limitation part time. Second division of the schedule has appeal, which is in days. Third division is also in days. Okay. Third division is the application in specified cases, that is also in days. So please mark this down and remember the days wala portion very carefully. Apart from this portion, every other description of application, you will see the limitation period is 3 years. Clear to everyone? Is this part clear? This is important and the part which you should note it down. Tanya, Shivani, Shaktija. So hope this is marked. So I'm telling again, these are the important section: 3, 4, 5, 6, 9. 3, 4, 5, 6, 9. Then 12, 14, 15, 18. Okay. 12, 14, 15, 18, 19. Then 21, 25. Okay. 26, 27 is also important. Mark that also. 26 and 27 is also important. Mark that also. And these are the important articles. Okay. 42, 54, 59, 60, 63, 64, 65, 75, 76, 78, 93, 96, 97, 102, 105, 107, 109, 110, 112, 115, 116, 118, 120, 121, 22, 23, 27, 130, 133, 135, 137. Okay, apart from that, also remember the time, a period of limitation for these sections, which I have noted here, for second division and for third division. Now, my question to all of you is, how many sections are there in Limitation Act? Please answer in the comment section. How many sections do you find under Limitation Act? Yes, students. How many sections can you see? There are 32 sections, right? It is divided into 5 parts. Limitation Act, if you see the arrangement of section, it's divided into 5 parts. Okay. Part 1 is the preliminary portion. Part 1, yes, Shaktija, correct. 32 sections. Yes, Tanya and Anjana, right. Now there are how many parts? If you only see the section, the arrangement of section, yes, Anjana, correct. 5 parts. And these 5 parts, how are they divided? If you see part 1, it is preliminary part with 2 sections. Okay. Preliminary part with first 2 sections, section 1 and section 2. Part 2, if you see, it deals with the limitation of suit, appeals, and application. Okay, limitation of suit, appeal, and application. It is from section 3 to section 11, right? So from section 3 to section 11 is dealt with in part 2. Now coming to part 3, computation of period of limitation. When you are calculating the period of limitation, what will be the procedure and rule? It's given from section 12 to section 24. This is my part 3, computation of period of limitation. And part 4 is acquisition of ownership by possession, okay, which is 25, 26, and 27. Very important again, 25, 26, 7. All these 3 sections are really, really important. Okay, I have also given you in that uh, important part. And part 5 is my miscellaneous: 28, 29, 30, 31, 32, out of which you just need to do 29, 30, and 31, because 20 and 28 and 32 are already repealed. Okay. Now if you see the schedule, if you see the schedule of the act, how many divisions will you find? It's not divided into articles directly, it's divided into divisions. So how many divisions do you see, students, in the schedule? There are 3 divisions. Okay, 137 articles have been divided into 3 divisions. See, The last one is third division, which is application. Now, again, these divisions are divided into parts. The division is divided into part. Okay. So you will find that first division contains 10 part. If I show you the first division, remember all this, okay, because it's a very small act, तो ये छोटी छोटी चीजें बहुत मैटर करती हैं for objective test. So the schedule, right, period of limitation, they are saying see section 2 clause J and 3, right? We will see that when we start the sections. फर्स्ट डिवीजन हमारा सूट है, सेकंड डिवीजन हमारा अपील है, और थर्ड डिवीजन हमारा एप्लीकेशन है. देयर आर थ्री डिविजन्स, रिमेंबर इट. फर्स्ट डिवीजन इज सूट, second division is appeal, and third division is application. Now first division is divided into 10 parts. Okay, if you see part 1, suit relating to account, part 2, suit relating to contract, right? Then you have uh, part 3, part 4, and like this you have 10 parts, right? The last part is part 10. So remember all the parts and which part is dealing with what, right? So mainly you will see all have 3 years limitation period, but some have 30 years and 12 years also. Just filter out those 12 years and 30 years and the days wala thing. Otherwise बाकी सबको आपको 3 years ही लगाना है. So first division, which is suit, contains 10 part, and it all deals with suit and limitation period for suit. Second division is my appeal. It has no part. Okay, second division is only appeal, divided into no part. It is from section 114 till section, see what is the section from 114 till 117, right? So 114, 115, 116, and 117 deals with appeal, and article 1 to article 113 is dealing with my suits. Okay, divided into 10 part. और थर्ड डिवीजन हमारा एप्लीकेशन है, जिसमें पार्ट 1 एंड पार्ट 2 है. पार्ट 1 इज माय एप्लीकेशन इन स्पेसिफाइड केसेस starting from 118 till 136. Okay, and part 2 is the last section, last article 137. Any other application for which no period of limitation is provided elsewhere in this division, okay, and the limitation period for this is 3 years only. Okay, it deals with that application for which there is no period of limitation provided anywhere in this schedule. Then it will be 3 years, it will be computed 3 years only. Yes, so I can see, yes, 5 parts, means 11 plus 117. Okay, what is this 11 plus and 117? Shaktija, see 10 parts, okay? For 3 divisions, the schedules are divided into 3 division. Part 1 is, first division is dealing with suit, second division deals with अपील, एंड थर्ड डिवीजन डील्स विद एप्लीकेशन. आप जब लिमिटेशन एक्ट के सेक्शंस भी पढ़ोगे ना, आपको दिखता है सूट, अपील, एप्लीकेशन. आप ये 3 चीज हमेशा नोट डाउन करोगे इवन इन योर सेक्शन, सूट, अपील, एंड एप्लीकेशन. सो सूट इज माय in the first part, in the first division of the schedule. It's divided into 10 parts. My appeal is dealt with under division 2, second division, and application is dealt with under third division. Third division has 2 parts. Okay, yes, second division sections, yes Shaktija, right, second division section, yes. So my second division is from, correct Shaktija, my second division is starting from 114 to 117. तो ये सारी छोटी छोटी चीजों को आपको याद करना है. इससे क्वेश्चंस आ सकते हैं, है ना. पार्ट 1 में क्या है ऑफ फर्स्ट डिवीजन, या पार्ट 2 में क्या है ऑफ फर्स्ट डिवीजन. हाउ मेनी पार्ट्स आर अपील डिवाइडेड इनटू, नो पार्ट, है ना. एंड थर्ड एप्लीकेशन पार्ट इज डिवाइडेड इनटू 2 पार्ट्स. सो चलो, ये तो हमारा एक ओवरव्यू हो गया, स्कीम हो गया ऑफ दिस एक्ट, राइट. नाउ कमिंग टू दी, if I start with the preamble, ठीक है, if I start with the preamble, it is Limitation Act 1963, Act number 36 of 1963, 5th October 1963 is given here. An act to consolidate and amend the law for the limitation of suit and other proceeding, and for purposes connected therewith, be it enacted by Parliament in the 14th year of Republic of India, as follows. Now, before गोइंग टू एनी अदर थिंग, मेरे को आपसे थोड़ा जानना है कि क्या ये लिमिटेशन एक्ट 1963 इज द फर्स्ट एक्ट डीलिंग विथ लिमिटेशन प्रोसीड्योर? Anjana has a question. Is there no prescribed period? It remains 3 years. Yes, yes, Anjana. So 137, Article 137 says कि अगर इस पूरे पार्ट में, राइट, आपका कोई डिफरेंट लाइक is not given, any period of limitation is not given for anything, then it will be taken to be 3 years only, right? So if, and it's not provided elsewhere in this division any other application, and it only applies for application, okay, not for suits and appeal. It is talking about application for which no period of limitation has been provided in the third division, then it will be 3 years. So right, so if it is not for suits, it's not for appeal, it is only for application, जिसके लिए थर्ड डिवीजन में कोई भी पीरियड ऑफ लिमिटेशन हमें नहीं दिया है, तो उसके लिए वी विल हैव 3 years ओनली, राइट? Yes. So there were others laws initially, right, Shaktija? And what were these laws? What were these act? Do you know the act before 1963 act? कौन से ईयर में क्या क्या एक्ट था? Who can tell me? You can just write down how many, how many acts were there before this. The law of limitation actually has developed in, yes, yes, first is 1859 act, correct. Law of limitation actually has, developed in stages. So there are stages of division for law of limitation. इट्स नॉट कि 1963 का एक्ट हमारा पहला एक्ट है, नहीं, इससे पहले हमारे पास देयर वेर प्रायर टू 1859, 1859 से पहले कोई एक्ट नहीं था, राइट? लेकिन उसके बाद इन 1859 एक लॉ आया रिगार्डिंग लिमिटेशन, राइट? देयर वाज अ लॉ, इट वाज एक्ट 14 of 1859, which was enacted, and it was applicable also to the court regarding limitation. Okay, so it was first in the year of 1859, and after that it got amended many times, it got repealed many times subsequently. uh, it was repealed, 1859 act was repealed, and then in 1871, 1877, and 1908 also acts were enacted, which were again repealed. And this last act before 1963 act, the last act was the limitation act of 1908. Before this current act, preceding act was limitation act of 1908, that was repealed by the third law commission, right? It was repealed by the third law commission, and now what we see, limitation act of 1963, that came into force after the 1908 act. It was only after the third, it was repealed by the third law commission, okay, remember this. So 1908 एक्ट और 1963 एक्ट में अगर आपको बेसिक एक डिफरेंस दिखेगा, तो वो आपको दिखेगा दैट 1908 एक्ट रेफर्ड only to foreign courts, right? Whereas 1963 act, if you see, it also talks about contracts which is entered into the territory of Jammu and Kashmir also, and also in a foreign country, if you see the 1963 act, right? बट इससे पहले जो 1908 एक्ट था, दैट वाज ओनली रेफरिंग टू फॉरेन कोर्ट्स. तो ये सारी कुछ चीज़ें हैं अबाउट द हिस्ट्री. नाउ लिमिटेशन एक्ट का पहले आई विल बी क्लियरिंग द ऑब्जेक्ट एंड सम बेसिक डॉक्ट्रिन्स जिसके ऊपर ये सारा पूरा एक्ट बेस्ड है. अगर आप ये नहीं समझते हो ऑब्जेक्ट ऑफ द एक्ट एंड द मैक्सिम्स विच आर रिलेटेड विथ this act, then you will not understand anything. So okay, I cannot see the act. Wait, I'll share with you the Bear Act first. So Yes. Now my Bare Act is visible to everyone. Limitation Act ka Bare Act is visible. Yes, students, is it visible? पहले तो आप समझ लो एक बात, दैट लॉ ऑफ लिमिटेशन जो है इट इज बेस्ड ऑन टू मैक्सिम्स. मतलब बहुत सारे मैक्सिम्स हैं यहाँ पर, बट अगर हम बेसिक अपने मैक्सिम की बात करें तो उसका रूट टू मैक्सिम्स में है. एक है हमारा इंटरेस्ट रिपब्लिके उट सिट फिनिस लिटियम. यू मस्ट हैव हर्ड ऑफ दिस maxim. Interest republicae ut sit finis litium. Okay, it means that it is in the interest of the state that हमें एक लिमिट लाना है या हमें एंड करना है लिटिगेशन. इन द इंटरेस्ट ऑफ द स्टेट देयर शुड बी एन एंड टू लिटिगेशन, right? There should be a limit to litigation, otherwise we cannot proceed further, our state cannot develop. तो उस इंटरेस्ट ऑफ द स्टेट के लिए आपको एक एंड करना ही है टू द लिटिगेशन. एंड सेकेंड मैक्सिम विच ऑन विच इट इज बेस्ड इज vigilantibus non dormantibus jura subvenient. If you want I can write these two maxims. I'll just share my screen with you all. So the maxims on which it is based, right? Interest republicae ut sit finis litium. And the second maxim which I have told is vigilantibus non dormientibus jura subvenient. Right? Just see the spellings, okay? If I have, because मैं अभी अभी मैंने टाइप करा यहाँ पर, so just see. So one is interest republicae ut sit finis litium. My screen is visible, right? Remember this two maxim. In the interest of the state, there should be an end to litigation. And vigilantibus non dormantibus jura subvenient. Yes, very good, Saharsh. Right. That you have to be vigilant. You have to be vigilant to your rights. You have to be vigilant regarding your rights. You cannot sleep upon it. And if you are sleeping upon your right, then we cannot help you. We are sorry, we cannot help you. So law of limitation is not actually telling you कि आप एक prescribed period of time के अंदर अपना सूट या अपील या एप्लीकेशन लाओ. नो, इट इज नॉट टेलिंग यू कि आप इस टाइम पीरियड के अंदर सूट अपील एप्लीकेशन लाओ. नहीं, वो एक्चुअली बोलता है दैट आप इस पीरियड के बाद अपना सूट अपील या एप्लीकेशन नहीं ला सकते. सो बेसिकली इट इज लिमिटिंग. ओके, इट इज नॉट टेलिंग यू दैट you cannot you bring your suit within this time, right? Indirectly it means the same, but it is actually saying that you cannot institute your suit or appeal or application, you cannot prefer after the period of time which has been prescribed by the limitation act. Correct? This part is clear to everyone. Now before I can proceed with the Bare Act, I told you that I'll give you a very short brief on the object, because object समझना काफी important है और इसको properly compile करने में I took a lot of time, so it will be helpful for you too. If you see the word limitation, okay, the word limitation in its literal sense, it is meaning a restriction, right? It means a restriction. अगर आप literal इसका interpretation देखो तो इसका मतलब होता है हम limitation लगा रहे हैं किसी चीज पर, मतलब हम उसको restrict कर रहे हैं, right? हम उसको limit कर रहे हैं. Now law of limitation is actually a procedural law or adjective law as we call it, because it is giving us a rule on procedure, and it is also prescribing a time limit within which you have to bring your suit, right? Within which an aggrieved party needs to bring the suit in the court of law. And if he brings his cause of action or his in the form of suit within that period, then he can claim his relief, then he will also get a remedy. But after this time limit, you are not getting anything. Whatever suit you institute, whatever appeal you prefer, whatever application you make, you will see these three terms with these three words. सूट के लिए हम इंस्टीट्यूशन वर्ड यूज करते हैं, टू इंस्टीट्यूट अ सूट. अपील के लिए हम क्या करते हैं, what do we use, preferring an appeal and making an application, right? application को हम institute नहीं करते, application को हम make करते हैं. सूट को हम प्रेफर नहीं करते, सूट को हम इंस्टीट्यूट करते हैं. तो ये सारे वर्ड्स पे प्लीज आप ध्यान रखना. नाउ लिमिटेशन एक्ट इज एक्चुअली प्रोवाइडिंग योर टाइम पीरियड आफ्टर द एक्सपायरी ऑफ विच आप अपना सूट इंस्टीट्यूट नहीं कर सकते इन एनी कोर्ट ऑफ लॉ बिकॉज इट इज बार्ड. ओके, इट इज बार्ड बाय लिमिटेशन एक्ट. हम देखेंगे सेक्शन 2 क्लॉज जे में what is the meaning of period of limitation and prescribed period, right? Now object is very clear. First thing, you have to understand that my limitation act is a statute of repose, peace and justice. ये पहला एक लाइन है जो आपको समझना है कि statute of limitation is a statute of repose, peace and justice. Please remember this, note it down. It's a statute of repose, peace and justice. Repose means we want to give some relaxation. It's, why it's a statute of repose, because it is designed only to bar actions after a certain period. आप certain period के बाद relax हो जाओ, you cannot institute a suit. That is why it is it's a statute of repose. ठीक है. Peace, why? Because it also quietens long possession and it extinguish stale demands. Some demands which has already become stale because आपने limitation period over कर दिया, you were sleeping over your rights, you came here after such a long period which has already crossed your limitation, then you were sleeping over your rights and your demand is a stale demand. So limitation act is also aiming to quieten long possession and to extinguish stale demand. So that is how it is obtaining peace, it is bringing security in the society. So it's a statute of peace, it's a statute of repose and it's a statute of justice. How is it giving justice? It is intending to give justice because it is taking into the ground reality of the parties, right? कि हम किसी भी पार्टी को कांस्टेंट डाउट, कांस्टेंट फियर, कांस्टेंट harassment में नहीं रखेंगे, right Saharsh? Long and dormant claim entails more harassment, correct? So since long and dormant claims are attracting harassment, it is destroying the peace and security of a society and also of the party, maybe of the defendant. So that is why we cannot leave a party, keep a a sword hanging over them कि उनको भी नहीं पता कि कब एक सूट उनके अगेंस्ट वापस हो जाए. तो एक टाइम पीरियड के बाद वो रिलैक्स हो जाते हैं कि अच्छा अब तो नहीं हो सकता because it is barred by limitation. Now statute of limitation, I already told you, is based on those two maxims which I have mentioned here, that is interest republica ut sit finis litium and vigilantibus non dormentibus jura sub venient, right? So according to Halsbury law, if you see, he has also said that Halsbury, agar aap law of England dekhoge, there are three cogent grounds. Three cogent grounds कि क्यों limitation act होना चाहिए. Halsbury law of England में 4th edition आप देखना, three cogent grounds have been mentioned कि why do we need a statute with limitation period. Why? Because as Saharsh has also pointed out, long and dormant claims cannot be entertained because it will create only harassment to the parties. It will be unfair that we leave a defendant with a fear that any time a suit can or an appeal or an application can be made against him, right? Second thing is कि after a certain period of time हम अपनी memory खो देते हैं या फिर we might have lost evidence, we might have lost a document, there must be death of witnesses, of memory has faded, जिसके कारण हम अपने सूट को या अपील को या एप्लीकेशन को प्रॉपरली डिफेंड नहीं कर सकते हैं. सो वी कैन नॉट डिस्प्रूव or we cannot deny your sayings if after a long period of time you are coming to me and I have already lost those evidences which I could have provided during the time period when the limitation was there. I kept it all, now I am relaxed कि अब तो इतना टाइम हो गया, ये वापस नहीं आएगा, and मैंने वो एविडेंसेस खो दिए हैं या वो विटनेसेस मर चुके हैं जो जो सपोर्ट में बात करते हैं. एंड थर्ड इज दैट इफ अ पर्सन इज हैविंग अ गुड कॉज ऑफ एक्शन तो आप रीजनेबल डिलीजेंस भी एक्सरसाइज करो. इफ यू हैव अ गुड कॉज ऑफ एक्शन, इफ यू हैव अ ग्राउंड, देन प्लीज बी diligent, please be vigilant and come to the court of law and seek your remedy as soon as possible. Don't delay. So my first thing is to quieten long possession and to extinguish stale demands. Okay. There are many cases, like one case is Rajendra Singh versus Santa Singh, right? Rajendra Singh versus Santa Singh. The AIR is 1973. Go through that case also. Rajendra Singh versus Santa Singh. AIR 1973. है ना. और स्टेट ऑफ राजस्थान वर्सेस रिकब चंद. स्टेट ऑफ राजस्थान वर्सेस रिकब चंद, AIR 1966. I cannot leave you with unlimited and perpetual threat of litigation, right? So this is my purpose of bringing limitation act. सो हम तीनों जगह से देखेंगे. पहला हम डिफेंडेंट के साइड से देखते हैं. डिफेंडेंट के लिए इट इज अनफेयर दैट वी लीव द डिफेंडेंट इन अ कांस्टेंट फियर दैट अ क्लेम कैन कम अगेंस्ट हिम एट एनी पॉइंट ऑफ टाइम. सो दैट इज नॉट फेयर ऑन द पार्ट ऑफ डिफेंडेंट. सेकेंड इज दैट अगर हम बहुत ऑब्जेक्टिव पॉइंट ऑफ व्यू से देखें तो हमें एक टाइम लिमिट भी चाहिए. ओके एक टाइम लिमिट जरूरी है जिसके अंदर आप अपना क्लेम अपना क्लेम या कोर्ट ऑफ लॉ के सामने प्रेजेंट कर सकते हो. Because with lapse of time, what happens, the documentary evidence is likely to get destroyed, memories are likely to get faded. So this is my second code, second reason. Third is that unnecessary delay is only leading in the loss of and destruction of documents and evidences. That is why we don't want long and unnecessary delay. And third is also relating to the conduct of plaintiff, कि अगर आप राइट हो तो आप प्रॉम्प्टली एक्ट करो. राइट. दिस इज माय लिमिटेशन का थिंग, दैट व्हाई लिमिटेशन एक्ट इज नीडेड. नाउ so object is clear to everyone, to quieten long position and extinguish stale demand, you know. So the necessity is that also the necessity arises from the perishable nature of man. वरना हमारे क्लेम्स तो इमॉर्टल रह जाएंगे पर हम तो मॉर्टल है ना. हमारा एक टाइम पीरियड है वेयर वी कैन वी विल पेरिश, वी विल डाई. सो क्लेम्स इमॉर्टल हो सकते हैं लेकिन हम तो पेरिशेबल नेचर के, हमारा मॉर्टल बीइंग है. सो वी नीड टू गिव अ पीरियड ऑफ लिमिटेशन टू everything where we can, so that if you want to seek your remedy, be diligent, be vigilant and come promptly, right? लेकिन ऑब्जेक्ट ऑफ जो लिमिटेशन है वो हमारा है टू बार द रेमेडी बट नॉट टू एक्सटिंग्विश द राइट. So first thing I told you was limitation is a statute of repose, peace and justice. It is there to quieten long position and bar the stale demands. Second part which you need to remember is that limitation period, limitation जो है act, it is barring my remedy but it is not extinguishing the right, right? लेकिन इसका एक exception है. If you can tell me which limitation bars the remedy but does not extinguish the right, right? So what is the exception? Anyone who can tell me which section is an exception to this part, that limitation bars the remedy but does not extinguish the right? What is the exception? 27. हम जब section 27 हम देखेंगे तो हम देखेंगे कि that is an exception to this general rule, that limitation bars the remedy but does not extinguish the right. ठीक है. Because section 27 में हमारा हमारे साथ ये होता है जब हम पढ़ेंगे that after certain time, right, आप राइट जो है वो भी आपका एक्सटिंग्विश हो जाता है. तो जनरली लिमिटेशन डज नॉट एक्सटिंग्विश राइट बट सेक्शन 27 आल्सो एक्सटिंग्विशेस द राइट आफ्टर अ सर्टेन. यस अंजना, राइट. आंसर 27, correct. So this part is clear. Now law of limitation is also retrospective in operation, and one more part is that law of limitation is lex fori or lex loci. Students, is it lex fori or is it lex loci? Limitation is lex fori, right? It is according to the law of forum where it is initiated and not the place where the cause of action arose. तो जहाँ cause of action कहीं पर हुआ और हमने सूट कहीं और इंस्टीट्यूट करा है, तो my procedure will not be governed by the place where the cause of action arose. It will be governed by the limitation period of the place where the suit is instituted. Remember this. Now let us come to the Bare Act. Right. Now, what is the short title, extent, and commencement of this act? This act is called Limitation Act 1963, extending to whole of India, right? Because पहले Jammu and Kashmir था, but after the जम्मू एंड कश्मीर रीऑर्गेनाइजेशन एक्ट, राइट, सो उसको हमने हटा दिया है, अब नाउ इट एक्सटेंड्स टू होल ऑफ इंडिया and it shall come into force on date as the central government may by notification in the official gazette appoint. Now come to the definition part. There are this definition, and if you see, there are definitions from A to N, so please remember and please try to remember each and every definition here. It's really important. Who is an applicant? Applicant includes a petitioner. Okay, it includes any person from or through whom an applicant derives his right to apply. Any person whose estate is represented by applicant as executor, administrator or other representative. So applicant के definition में ये तीनों आ जाते हैं. Petitioner भी आता है, या कोई और person जिससे applicant is deriving his right to apply, या कोई और person whose estate is being represented by the applicant as executor, administrator or other representative. And what is application? Application includes a petition. Bill of exchange क्या है? Bill of exchange is including a hundi and a check. Remember this. Okay, just remember all this thing which I'm showing here. Wait, I'll just show you another screen. See, those two principles is mentioned here. Hope everyone can see my screen. It's visible, right, to everyone? Yes. Now these are my two maxims. अगर आप यहाँ देखो, what is the policy behind prescribing a period of limitation? If you see, please open your Bare Act, student, so that we can read it from here only for better understanding. Bill of exchange में क्या है? Bill of exchange includes hundi and check, right? Just open your yeah. So applicant में कौन कौन आता है? Who all are there in applicant, students? It's petitioner, or any person from or through whom an applicant is deriving his right to apply, or any person whose estate is represented by the applicant as executor, administrator or other representative. Section 2 clause A. Okay, if you come to 2 clause B, it's defining application, which includes only a petition. ठीक है, application मतलब क्या है यहाँ पर? Petition. It includes a petition. Okay, so it is also including a petition. Bill of exchange में क्या है? Bill of exchange is my hundi and check. Section 2 clause C. It includes hundi and check. And 2 clause D is defining bond, which includes any instrument whereby a person is obliging himself to pay money to another on a condition that the obligation shall be void if a specified act is performed or is not performed, as the case may be. So section 2 clause D is bond. Come to section 2 clause E, which defines defendant. Who is a defendant? जैसे हमने applicant पढ़ा, it includes a petitioner and any person from whom he derives his right, and any person whose estate is representative. Defendant here includes any person from or through whom a defendant is deriving his liability to be sued, and any person whose estate is represented by the defendant as executor, administrator or other representative. This defines defendant. Good faith का क्या मीनिंग है? सेक्शन 2 क्लॉज एच में. ई के बाद एक और है एफ, वो आप देख लेना. ईजमेंट, अगेन इट इज इम्पोर्टेंट. ठीक है, 2 क्लॉज एफ, ईजमेंट इज इम्पोर्टेंट. व्हाट इज ईजमेंट, स्टूडेंट? It's a right not arising from contract. So any right which is not arising from contract, by which one person is entitled to remove and appropriate for his own profit any part of the soil belonging to another, or anything growing in or attached to or subsisting upon the land of another. ये एक important definition है 2 clause F में easement का. What is easement? What is easement, students? Anyone who can tell me the meaning of easement? What is easement? आप अगर सेक्शन 4 देखो ऑफ ईजमेंट एक्ट भी, वहां पे भी ईजमेंट इज डिफाइंड, राइट? सो it's a right which is not a, I don't have any contract with you, but still I'm getting a right, like a right to support, or a right to way, or a right to, ferry, right to plot in your land, because I have been doing that from a long time. So after a period of time, I get a right that I can use your land for my purpose. If I have been using it for a long time, I get an easementary right, right? And it is not arising from contract, it is only because I have been using that part from a long time, so I'm getting that easementary right. Okay, so this is easement. Coming to section 2 clause G, foreign country means any country other than India. H, good faith. What is good faith? Section 2 clause H में. Right, Sarj, in TP Act you get it right. You have a right to enjoy your land, right? And easement के थ्रू क्या होता है कि आप किसी आपको एक राइट मिल जाता है टू यूज हिज लैंड विच इज बिलोंगिंग टू समवन एल्स. Okay, but you are getting it to use because you have been using it for a long time, and it's a right which is not arising from any contract. Okay, what is good faith? According to this definition, good faith means what? If it is not done with due care and anything, nothing shall be deemed to be in good faith if it is not done with due care and attention. तो अगर आप ड्यू केयर एंड अटेंशन के साथ करते हो, तभी हम समझेंगे दैट आपने गुड फेथ में करा है. बट अगर आपने उतना स्टैंडर्ड ऑफ केयर या अटेंशन नहीं लिया है, राइट, सो वी विल से वी विल नॉट टेक इट इन गुड फेथ, राइट? सो सेक्शन 2H ऑफ लिमिटेशन एक्ट में भी गुड फेथ डिफाइंड है. It's also defined under section 52 of IPC, but it is little different from what has been defined in section 3 clause 22 of General Clauses Act. Okay, and one important case regarding good faith is Chaman Lal versus State of Punjab, जहां पे कोर्ट ने बोला था that good faith requires care, caution and prudence. Now, period of limitation, section 2 clause J, very important. What is period of limitation? What do you mean by period of limitation? Period of limitation means the period of limitation prescribed for any suit, appeal or application by the schedule. ठीक है, तो this period of limitation is the period of limitation prescribed for suit, appeal or application by the schedule. And prescribed period मतलब क्या होता है? Period of limitation computed in accordance with the provision of the act. तो ये दोनों different चीजें हैं. Period of limitation is different and prescribed period is different. Period of limitation is that which is given in the schedule, 3 years, 12 years, 30 years, okay, or days, whatever is given. Prescribed period होता है जब हम calculate करते हैं, right? The period which is calculated is my prescribed period, which is computed in accordance with the provision of this act only. So prescribed period we calculate through this period of limitation only, but period of limitation is the thing given in the schedule, mentioned in the schedule, 3 years, 12 years, like that. But prescribed period is that which we calculate. Okay, now section 2K, promissory note. What is a promissory note? Any instrument whereby the maker engages absolutely to pay a specified sum of money to another at a time therein limited or on demand or at sight. तो promissory note क्या है? It's a plain and direct acknowledgement जो हम writing में देते हैं किसी को. It's an instrument जिससे हमने किसी को promise करा है that we will pay a sum of money to them in this period which is mentioned there. Okay. अच्छा, अगर आप एनआई एक्ट देखो, एनआई एक्ट में भी a promissory note is defined in section 4, right? Then section 2 clause L is defining suit. Suit does not include an appeal or an application, right? Suit does not include an appeal or an application. But application includes what, students? It includes a petition as mentioned in section 2 clause B. ये सारी चीजें याद रखना. An important definition again is given in section 2 clause M, that is tort का definition. अब tort का definition आप लोगों ने already tort में पढ़ा होगा. It's a civil wrong, right? Which is for which the remedy is in common law action for unliquidated damages and which is not exclusively breach of contract or breach of trust or other merely equitable obligation. ये Salmon ने define करा था. Section 2M में क्या है? Section 2M says tort means a civil wrong. Of course, tort is a civil wrong which is not exclusively the breach of contract or breach of trust. ये Salmon की definition में भी है. It's not exclusively breach of contract or breach of trust. So this is the definition of tort. And section 2 clause N, if you see, it is trustee. See your Bear Act. See all of you, I hope you are having the Bear Act. Otherwise, it will be problematic for you to understand and to keep a pace. Trustee does not include a benamidar. It does not include a mortgage or mortgagee remaining in possession after the mortgage has been satisfied or a person in wrongful possession without title. तो ये हमारा ट्रस्टी का डेफिनेशन है, राइट? सो बेनामीदार कौन होता है? In whose name you have purchased the property but he is not the actual owner, but आपने उसके नाम पे property खरीदा है, right? So this is trustee. Now let us come to section 3. 2 is clear. Section 2 is definition. I hope everything is clear from this part. Easement का definition important है. Tort पूछा जा सकता है, suit पूछा जा सकता है, यहाँ पे period of limitation पूछा जा सकता है, तो please इसको आप learn करना. Easement, then period of limitation, suit, tort, ये सारे important definitions हैं. Now let me just go to the act. Section 3, as I have mentioned in my वो starting में ही मैंने mention करा, section 3 is important. It's limitation of suit, appeal and application. It's in part 2, okay? It's coming under part 2 heading limitation of suit, appeal and application, which is from section 3 till section 11. Part 2 में हम देखेंगे section 3 से section 11 तक sections दिए हैं. Now what is bar of limitation? Section 3 देखो आप लोग. Bar of limitation. First thing, this section is subjected to section 4 to 24 inclusive. हाँ, तो ये section 3 जो है ये एक general rule है, but it is subject to section 4 to 24, right? And it says that every suit instituted, appeal, prefer and application made. मैंने आपको बताया था suit के साथ हम institution रखते हैं, appeal के साथ prefer and application के साथ made. After prescribed period shall be dismissed although limitation has not been set up as a defense. तो अगर आप एक प्रेस्क्राइब पीरियड के बाद अपना सूट लाते हो या अपना अपील प्रेफर करते हो या एप्लीकेशन करते हो तो उसको डिसमिस कर देगा कोर्ट, ठीक है? आपने लिमिटेशन को डिफेंस लिया है, लिमिटेशन को डिफेंस नहीं लिया है, डज नॉट मैटर, इट इज गोइंग टू बी dismissed by the court of law, right? And for the purpose of this act, आप देखो, suit is instituted when is a suit set to be instituted, students? See, suit हम कब institute करते हैं? आपने CPC में पढ़ा है, जब हम plaint present करते हैं. CPC में हमने पढ़ा ना, suit is a civil proceeding which starts with the presentation of a plaint. तो सेम चीज यहाँ भी दिया है. Suit is instituted in ordinary case when the plaint is presented in the proper officer. तो पहली चीज तो ये कि आपको plaint proper officer को present करना है, not to a wrong officer. Pauper के केस में suit will be instituted जब उसकी application for leave to sue as a pauper is made. एंड इन केस ऑफ अ क्लेम अगेंस्ट अ कंपनी जिसको हम वाइंड अप कर रहे हैं, व्हेन द क्लेमेंट फर्स्ट सेंड इन हिज क्लेम टू द ऑफिशियल लिक्विडेटर, so in this case suits get instituted, and any claim by way of set off or counter claim will be treated as a separate suit. अगर हम counter claim कर रहे हैं या set off कर रहे हैं तो उसको एक separate suit माना जाएगा, and that will be deemed to have been instituted in case of set off on the same date as the suit in which the set off is pleaded, and in case of counter claim on the date on which counter claim is made in the court. इसका क्या मीनिंग है, इसको समझना थोड़ा इम्पोर्टेंट है. इसका क्या मीनिंग है, क्या आप बता सकते हो? Anyone who can tell me ये क्या डिफरेंस हो रहा है सेट ऑफ और काउंटर क्लेम के केस में? पहली चीज आप देखो, सेक्शन 3 जो है ये हमारा जनरल रूल है दैट सूट विल बी डिसमिस्ड आफ्टर द prescribed period if it has crossed the prescribed period. So it's founded on public policy. So we are saying that okay, अगर आप एक लिमिटेशन पीरियड के बाद आते हो तो हम आपका सूट क्या करने वाले हैं, डिसमिस करने वाले हैं. लेकिन ये जो सेट ऑफ और काउंटर क्लेम की यहाँ बात हो रही है, व्हाट इज दैट? हु कैन टेल मी? यस. Yes, students, tell me. Just read. In case of set off on the same date as the suit in which the set off is pleaded. सोचो आपका set off करने का डेट एक लिमिटेशन, these two are separated as separate, these two are treated as separate suit. मुझे सेट ऑफ करना है आज, मैंने अपना सूट इंस्टीट्यूट करा है ऑन 1 जनवरी, राइट? मेरा सूट इंस्टीट्यूट मैंने करा है ऑन 1 जनवरी. सेट ऑफ का भी डेट उसी दिन माना जाएगा. दैट सेट ऑफ इज ऑल्सो क्लेम्ड ऑन 1 जनवरी, नॉट ऑन द डेट. मे बी आई हैव claimed my set off later. I claimed set off, say for example limitation period था मेरा 1 February, okay, to institute the suit. तो मैंने सूट को ऑलरेडी 1 जनवरी को इंस्टीट्यूट कर दिया था, बट सेट ऑफ मैंने क्लेम किया है 5 फरवरी को. नाउ 5 फरवरी इज अ डेट विच इज आफ्टर लिमिटेशन पीरियड, लेकिन सूट तो ऑलरेडी इंस्टीट्यूट हो गया था. और सेट ऑफ का डेट कौन सा डेट माना जाता है? ऑन विच द सूट इज इंस्टीट्यूटेड. तो भले ही मैंने सेट ऑफ फरवरी के बाद क्लेम करा, बट सेट ऑफ का डेट सूट का ही डेट माना जाएगा, मतलब 1 जनवरी ही माना जाएगा. बट इन केस ऑफ काउंटर क्लेम ऑन द डेट ऑन विच काउंटर क्लेम इज मेड इन कोर्ट. तो सेम चीज अगर काउंटर क्लेम के लिए करते हैं हम, और मेरा लिमिटेशन पीरियड ओवर हो रहा है ऑन 1 फरवरी, और मैंने काउंटर क्लेम करा है ऑन 5 फरवरी, लेकिन सूट मैंने ऑलरेडी इंस्टीट्यूट करा था जनवरी में ही, तो क्या काउंटर क्लेम विल बी taken or not taken? Will it be taken or will it be dismissed? What do you think? Yes. So if my limitation period is till 1 February, मैंने 1 जनवरी को ही अपना सूट इंस्टीट्यूट कर दिया, लेकिन मैंने काउंटर क्लेम के लिए एप्लीकेशन दिया है ऑन 5 February. So will it be taken by the court or will it not be taken by the court? It will be dismissed. Very good, because काउंटर क्लेम का डेट इज ट्रीटेड टू बी द डेट ऑन विच इट इज गिवन. लेकिन यही चीज अगर हम सेट ऑफ के लिए करते हैं, सेट ऑफ के लिए अगर हम करते हैं कि सेट ऑफ को मैंने 5 फरवरी को करा है, तो वो डिसमिस होगा या नहीं होगा? सेम सर्कमस्टांसेस ऑफ द केस. 1 फरवरी को लिमिटेशन पीरियड ओवर हो रहा है, 1 जनवरी को सूट मैंने इंस्टीट्यूट इसीलिए करा ताकि 1 फरवरी तक बात ना जाए, लेकिन सेट ऑफ मैंने क्लेम करा है 5th को. तो विल इट बी एक्सेप्टेड और विल इट बी रिजेक्टेड? What about set off? Set off will be accepted. Why? Because set off का डेट माना जाता है सूट का ही डेट. सेट ऑफ का डेट और सूट का डेट सेम माना जाता है, तो भले ही सेट ऑफ मैंने 5 फरवरी को क्लेम करा है, बट सूट तो 1 फरवरी का है ना, तो सेट ऑफ का भी डेट सूट का ही डेट माना जाएगा, दैट इज 1 फरवरी. दिस इज व्हाट this section is saying. And an application by notice of motion in a high court is made when the application is presented to the proper officer of the court. Application कब करते हैं हम? जब हम उसको proper officer को देते हैं. It should not be to a wrong officer. It should be made to the proper officer. Okay. This is my section 3. Now section 3, if you see, is section 3 is mandatory. ठीक है, सेक्शन 3 इज मैंडेटरी, क्योंकि हमारे पास यहाँ पे कोई भी प्रोवाइजो हमें दिया नहीं है, राइट? इट्स मैंडेटरी सेक्शन. तो आफ्टर दिस the case is liable to be dismissed if it is coming after the limitation period. So there is a bar of limitation, right? Some suits are barred by territorial jurisdiction, some by pecuniary jurisdiction, some suits are barred for limitation period also. Now, second thing, uh, this section 3 is actually being subjected to section 4 to 24. So section 4 to 24 is regulating section 3. अगर आप देखोगे तो section 4 से लेकर 24 inclusive is regulating section 3, because this section has been subjected to this section and it is, controlling this part of section 3. तो भले ही टाइम पीरियड, इस टाइम पीरियड के बाद अगर आप आते हो तो आपका सूट डिसमिस हो जाएगा, बट सेक्शन 4 से लेकर 24 में कुछ चीजें दिया है जहां पर हम पीरियड को एक्सटेंड कर सकते हैं. तो कम टू सेक्शन 4. एक्सपायरी ऑफ प्रेस्क्राइब पीरियड व्हेन कोर्ट इज क्लोज्ड, और इसके साथ एक एक्सप्लेनेशन भी दिया है. सो जस्ट मान लो कि आपने जिस दिन लास्ट डे ऑफ लिमिटेशन पीरियड है, लास्ट डे है हमारा सूट फाइल करने का, और आप देखते हो कि आज ही एक छुट्टी पड़ गया है, राइट? एक हॉलीडे है, से फॉर एग्जांपल ईद है या होली है या बकरीद है, कुछ हॉलीडे है, या उस दिन ड्यू टू सम रीजन द कोर्ट इज क्लोज्ड. So what will happen? Can you institute your suit or appeal or application? Can you prefer this? Now this section applies to everything, suit also, appeal और also an application. ये second चीज है जो आप ध्यान में रखोगे कि कौन सा section किस चीज को अप्लाई करता है, बिकॉज कुछ सेक्शन है जो सिर्फ सूट्स को अप्लाई करते हैं, कुछ सेक्शन है जो अपील को अप्लाई करेंगे सिर्फ, कुछ है जो सिर्फ एप्लीकेशन को अप्लाई करेंगे, और कुछ है जो सब तीनों को अप्लाई करेंगे, राइट? तो सेक्शन 4 is important again, dealing with all suit, appeal and application, right? So if on the day the court is closed, then you can come on that day when the court reopens. सेकेंड ही डे. अब ये नहीं कि कोर्ट रीओपन मंडे को कर रहा है तो हम ट्यूसडे जाएंगे और फिर बोलेंगे कि नहीं, इस दिन को तो आई केम ऑन सैटरडे, सैटरडे इट वाज क्लोज, संडे तो ऐसे भी हॉलीडे होता है, तो आई एम कमिंग ऑन मंडे, आई एम कमिंग ऑन ट्यूसडे. Court will ask you what were you doing on Monday. You have to come, promptly on the day when the court is reopening. And explanation is also given. अगर सोचो एक कोर्ट हाफ डे के लिए खुला है तो क्या उसको क्लोज मानेंगे या ओपन मानेंगे? If a court is open only for half day, तो उसको हम ओपन मानेंगे कि कोर्ट ओपन था या कोर्ट क्लोज्ड है उस दिन? बताओ. कभी कभी ऐसा होता है कि कोर्ट इज नॉट ऑफिशियली क्लोज नहीं है, बट हाफ डे कर इट इज क्लोज एंड यू आर कमिंग आफ्टर 2 o'clock, राइट? तो उस दिन को भी क्या माना जाएगा? क्लोज ही माना जाएगा. सो फॉर एनी पार्ट ऑफ इट्स नॉर्मल वर्किंग आवर, इफ इट इज नॉट फंक्शनिंग, इट विल बी डिम दैट इट इज क्लोज्ड. सो कोर्ट इज नॉट ओपन जस्ट बिकॉज मेरली उसके दरवाजे खुले और आप आ जाओ. नो. Okay, just because people are sitting there and things are going on. If the work is not going on and if the suit cannot be instituted or appeal cannot be preferred or application cannot be made on that day, then it will be deemed to be closed only. ठीक है? और कोर्ट का मतलब यहाँ पे रॉन्ग कोर्ट नहीं है. ये नहीं कि आप किसी और कोर्ट में चले जाओ, किसी और जुरिस्डिक्शन जहां पर नहीं है, आपको सही कोर्ट में ही अपना एप्लीकेशन प्रेफर मेक करना या सूट और अपील प्रेफर करना. Okay, now come to section 5, which is again very important. Now section 5 is too important a section in this whole limitation act. अगर आपको section 5 नहीं पता है तो कुछ नहीं पता. section 5 is dealing with condonation of delay. condone करना delay मतलब हमारा कोर्ट जो है वो हमारे डिले को, भले ही हमने डिले करा ना, दिस इज एन एक्सेप्शन. सेक्शन 5 इज एन एक्सेप्शन टू सेक्शन 3. सेक्शन 3 क्या बोलता है कि टाइम पीरियड इतना था, हमने आपको दे दिया कि 1 जनवरी आपका लास्ट डे है टू सबमिट टू इंस्टीट्यूट योर सूट, बट अगर आप नहीं करते हो तो आई विल बी डिसमिसिंग इट. But section 5 says even after that, if you come after the prescribed period, you can make your, you can prefer your appeal or you can make your application only in certain cases. Section 5 is telling that cases, मतलब your delay can be condoned. condone मतलब delay आपका माफ हो जाएगा, भले ही आप प्रेस्क्राइब पीरियड के बाद आए हो, बट आपका डिले हम माफ कर रहे हैं. वाई? बिकॉज यू कैन शो मी सफिशिएंट कॉज. If you have sufficient cause due to which you cannot prefer the appeal or you cannot make the application within that time period, then your delay will be condoned by the court. One very important thing to note down is section 5 is not applying to suits. So delay cannot be condoned under section 5 for suit. It's only for it's only for appeal and for application. इट डज नॉट अप्लाई टू सूट. ये बहुत इंपॉर्टेंट चीज है. इंटरव्यू में एमसीक्यूज में ये पूछ लेते हैं, डज इट अप्लाई टू सूट, डज इट अप्लाई टू अपील. तो यू हैव टू राइट and it's only applying to appeal and application, that to application other than application mentioned under order 21 of CPC. 21 deals with execution, right? So if it is any appeal or application other than application for made under the provision of order 21, it can be admitted after a prescribed period when, if you can show me a sufficient cause, the ground is sufficient cause on which the court will allow you to institute to prefer your appeal or to make your application other than this application, if you can show a sufficient cause. And what does the explanation say? The fact that applicant or applicant was missed by any order, practice, or judgment of High Court in ascertaining or computing the prescribed period may be sufficient cause within the meaning of this section. So, अगर आप High Court या you are missed by any, you have actually mistaken by any, you are actually mistaken by order, practice, or judgment of High Court to compute, to calculate your time period, that is also a sufficient cause under section 5, and your delay will be condoned under section 5. So explanation is also very important. But आप एक चीज याद रखो, it does not apply to suit. Okay, it does not apply to suit. And the grounds on which you can शो दैट यू हैड सफिशिएंट कॉज. ठीक है, पहले तो कुछ कुछ ग्राउंड्स है जहां पे पर आप सफिशिएंट कॉज क्लेम कर सकते हो, जिसको कोर्ट ने हेल्ड करा है कि हाँ ये सफिशिएंट कॉज है. जैसे काफी सीरियस इलनेस इज अ सफिशिएंट कॉज, वेरी सीरियस इलनेस, या बोनाफाइड मिस्टेक, right? Bonafide mistake, a genuine mistake. If you have taken a wrong proceeding in good faith, if there is a bona fide mistake in calculation of time period, if you were imprisoned in jail, that is also a sufficient cause that the person who has to prefer the appeal is in jail. Mistake of your counsel is also a sufficient cause. And grounds which are not held to be sufficient is very minor illness. आप ऐसे बीमार हो कि बस आपको खांसी सर्दी है, राइट, बस आपको कफ एंड कोल्ड है, देन यू कैन नॉट टेल दैट इज अ सफिशिएंट कॉज, राइट? Or poverty is not a sufficient cause, that I'm poor, I cannot I cannot prefer an appeal just because I was poor. No, you have free aids also, free legal aid, you should go for that. Negligence of pleader or his clerk. ठीक है, now bona fide mistake of counsel is allowed as a sufficient cause, but negligence of a pleader or clerk, if he is negligent, then it is not allowed. ठीक है, so there are cases which you should read. There are some very important cases which you should go through. Please note that down. One case which I feel is very important is the state of West Bengal versus Administrator Havra Municipality, AIR 1972. Second case is Ramlal versus Rewa Cold Fields. आपको ये cases मिला होगा बहुत सारे जगह पे. Ramlal versus Rewa Cold Field is also important, right? One more case, collector land acquisition, Anantnag. Collector land acquisition from the place is Anantnag versus Kaliji. It's a case of 1987. AIR is 1987. And grounds held not sufficient में आप एक case note down करो, which is Banarsi Das versus state of UP. Banarsi Das versus State of UP, AIR 1956. One more case is Gertred, Gertred, Gertred Chanda versus Habitat Developers Limited. Now, these cases are important when you read Section 5. Also, to mention that Section 5 is not mandatory, it is discretionary. The court will decide whether it needs to condone or not condone. We cannot tell that आपको condone करना ही है. It is Section 5 is not giving you a right. ठीक है? It's a discretionary power of the court whether they will be condoning the delay or they will not condone the delay. Like there are cases, okay, where the applicant was suffering from fever, ठीक है, and that is why he there was a delay in making the application because he was suffering from fever. That was condoned by the court, right? Second case is where there was a delay of 4 days in filing an appeal. Okay, the person came after 4 days after the prescribed period. 4 days बाद आता है, so there's a delay of 4 days because he was consulting a law book जिसको publish करने में देर हो गया. Okay, and he wanted to see the latest amendment. That is also held to be a sufficient cause. So these are the cases where it is sufficient cause. uh, One case where, if you cannot explain your delay, then the delay will not be condoned. एक और केस था जहां पे देर वॉज अ डिले बिकॉज द एपेलेंट वॉज अरेस्टेड, सो ही वॉज इन जेल. लेकिन उसको कोर्ट ने कंडोन नहीं करा. यू नो वाई? बिकॉज because he had sufficient time he had sufficient time to uh, file this his case beforehand. तो ऐसा नहीं कि जिस दिन से स्टार्ट हुआ और आप एंड में अरेस्ट हो गए, आपको उससे पहले ample time था to file the appeal before arrest, and that is why the delay was not condoned. Yes, so I'll just jot down the cases so that you can go through these cases which I feel are important. Just see the comment box. I'm writing in the comment box the cases. Okay. Ramlal versus Reva Coalfields. AIR is 1962. State of West Bengal versus Administrator. Just take care of the spellings because I'm writing here now, so there can be typo errors. Okay. AIR 1972. I hope it is visible to everyone, the cases in the comment section which I am writing. ये सेक्शन 5 से रिलेटेड सारे इंपॉर्टेंट केसेस हैं. हाँ, right, so I've just mentioned those cases. Then Banarsi Das versus State of UP, Gurpreet Chanda versus Habitat Developers Limited. And there are many cases relating to section 5 जहाँ पे different case different situations है जहाँ पे कोर्ट ने कंडोन करा है कंडोन नहीं करा है. And condonation of delay is not a matter of right. Section 5 is not giving you any right. It is completely on the discretion of the court to condone or not condone on the circumstances of the cases. Okay. So if the court finds that नहीं इसको कंडोन नहीं करना है तो वो नहीं करेंगे, और अगर कंडोन करना है तो वो करेंगे. ओके, उनके ऊपर है. अगर उनको ये लगता है दैट these are the grounds for sufficient cause to condone the delay, okay, then your prescribed period will be extended. So this is a, as already mentioned, that section 3 is being regulated by section 4 to section 24. So see, section 5 is an exception. Now come to section 6, legal disability. लीगल डिसेबिलिटी का सेक्शन जो है बहुत इंपॉर्टेंट है, राइट. नाउ इफ यू एनालाइज दिस सेक्शन प्रॉपरली, लीगल डिसेबिलिटी मतलब क्या होता है? व्हाट इज लीगल डिसेबिलिटी? हु कैन टेल मी लीगल डिसेबिलिटी का मीनिंग? Yes, students, who can tell me the meaning of legal disability? Yes. If you see legal disability, it is, it is the state of, like, legally you are disabled, not medically disabled. Okay, यहाँ पे कोई medical disability नहीं है, आपकी legal disability. Why? Because you are a minor. Either you are a minor, or you are insane, or you are an idiot. So if you are a minor person, due to your age, you are not legally qualified to इंस्टीट्यूट अ सूट, है ना. या फिर अगर आप इंसेन हो या इडियट हो, देन ऑल्सो यू आर नॉट क्वालिफाइड टू इंस्टीट्यूट अ सूट और मेक एन एप्लीकेशन. सो सेक्शन 6 इज टॉकिंग अबाउट दैट ओनली. अगर हम सेक्शन 6, 7, 8 ये तीनों देखें तो आपको दिखेगा सेक्शन 6, 7 and 8. सेक्शन 6 टॉक्स अबाउट लीगल डिसेबिलिटी, सेक्शन 7 talks about disability of one of these several person, and section 8 is special exception. So section 6, 7 and 8 are to be read together. Okay, they all are dealing with what? They all are dealing with the disability of a person. Now the feature of section 6 is that it is applicable to suits and execution proceedings. अगर आप देखो section 6, what is section 6 talking about? It will talk about suits, and it will talk about execution proceeding. So when the applicant is a minor, he will be allowed to file a suit on attaining majority, and the prescribed period will begin from the date on which he attains majority. So section 6 is talking about legal disability. An object of section 6 is to protect the interest of minor and to protect the interest of such people who are not competent or who are in a disadvantaged position, and in the eye of law they are like incapable to understand unke consequences of their act or their omission. That is why section 6 says that if a person is a minor, if a person is a insane person or an idiot person, तो हम उसके लिए टाइम क्लॉक को रोक देंगे और उसको अलाउ करा जाएगा कि वो अपना सूट मेजॉरिटी अटेन करने पर फाइल करे. And the prescribed period of limitation will also begin from the date on which he attains majority. So if, say for example, there is a cause of action which has arose for which you want to file a suit, but right now you are 12 years and the limitation period is 3 years, but आपके पास 12, आप अभी 12 साल के हो और आपके पास लिमिटेशन पीरियड 3 साल है, मतलब 15 ईयर्स के अंदर अंदर आपको सूट फाइल करना, वरना आप और नहीं कर पाओगे. बट बिकॉज यू आर अ माइनर, सेक्शन 6 इज गिविंग यू अ advantage. Okay, you can institute your suit when you reach 18 years, and your limitation period will also start after that. That means limitation will start after you attain majority. तो टाइम क्लॉक अभी के लिए ये रुक जाएगा. एंड अगर एप्लीकेंट इंसेन है या इडियट है, then he can file his suit when he becomes sound mind, and then also it will begin only from the date when he gets his sanity. अगर ऐसा है कि applicant is suffering from two disabilities at the same time, right? Two disabilities at the same time, say he's a minor person also and he is also insane. ऐसा हो सकता है ना कि a child is insane plus he's a minor also. So if he's running from two disability, then period of limitation will only begin when both the disability have ceased to exist. And if he's suffering with a disability and सोचो अभी आई एम अ माइनर पर्सन एंड आई एम लाइक सेन, आई एम अ माइनर बट आई एम सेन, ही इज 12 years but he is sane. The moment he is about to reach 18 years he becomes insane. So he was, ही वॉज, एक डिसेबिलिटी सीज हुआ और दूसरा डिसेबिलिटी इफेक्ट करता है आपको, तो एक डिसेबिलिटी खत्म होने पर ही दूसरा डिसेबिलिटी अगर आपको इफेक्ट करता है, देन आप इंस्टीट्यूट कर सकते हो अपना सूट after both the disabilities have ceased and within the same time period जो आपको अलाउ करता from the time so specified. And if the disability is continuing till death, सोचो आप कभी सही ही नहीं हुए, if an insane person is insane till his death, then his legal representatives will get a fresh period of limitation. That means his the time clock will be stopped till his death and his legal representative will get a fresh period of limitation, राइट. अगर ऐसा है कि लीगल रिप्रेजेंटेटिव्स भी डिसेबल्ड है, फॉर इंस्टेंस दे आर माइनर और इनसेन, then period of limitation shall be begin from the date when the legal representative is able to file a suit, right? And if a person is dying after the disability has ceased to exist but within the period allowed to him under this section, his legal representative can institute a suit or can make an application. So section 6 applies to suits and applications. See this, it does not apply to appeal. ठीक है, देख लो. And for the purpose of this section, the explanation says minor includes a child in the womb also. अगर आप explanation देखो, minor also includes a child in the womb. So this is section 6, legal disability. Come to section. Now, section 6 is applied only for, as I've already told you, to suits and execution proceeding, right? It will not apply to appeals, okay? And if you want to bring a suit on the after period of limitation saying that you were legally disabled, you have to show that the disability was continuous. ऐसे नहीं होना चाहिए कि अभी आप disabled थे, like I am a minor and then I reached 18 years, फिर 20 years तक I am good and 21 years से again I become insane. तो आपको वो जो 2 साल का टाइम गैप बीच में था 18 to 20, जब आप अच्छे कंडीशन में थे, आपको सूट फाइल कर देना चाहिए था, राइट? सो इट शुड बी आइदर कॉन्टिन्यूअस, इट शुडंट बी ब्रेकिंग अप, ओके? एंड डिसेबिलिटी मस्ट बी ऑफ अ पर्सन हु इज इंटाइटल टू सू और अप्लाई. ये किसी और की डिसेबिलिटी नहीं है, ये उस पर्सन की डिसेबिलिटी है जिसको सू करना है या अप्लाई करना है फॉर एग्जीक्यूशन, राइट? एंड ही इज ऑलरेडी अंडर डिसेबिलिटी व्हेन दिस राइट इज गिवन टू हिम. ऐसा नहीं कि बाद में वो डिसेबल्ड हो गया, उसका डिसेबिलिटी पहले ही होना चाहिए. द मोमेंट दिस राइट अक्रूज टू हिम ही शुड बी डिसेबल्ड. नाउ सेक्शन 7 सेज अबाउट डिसेबिलिटी ऑफ वन ऑफ सेवरल पर्सन्स. अभी एक सोचो, एक एग्जाम्पल है दैट देर आर मेनी पीपल हु आर जॉइंटली इंटाइटल टू इंस्टीट्यूट अ सूट. सो सेवरल पर्सन्स आर entitled to institute this suit jointly. Now this is very important section. ठीक है, इसमें कुछ कुछ एग्जांपल्स आते हैं which I will discuss with you. And what happened, one of them is disabled, so can the other people institute a suit on his behalf or without him? Can it happen? Like A, B and C, say for example A, B and C are partners in a firm. A, B and C are partners in a firm and E and F are insane, right? E and F are insane at the time and G is a minor. So when can the limitation period start? इफ चलो मान लेते कि जी मेजर हो भी जाए, तो क्या वो अकेले सूट फाइल कर सकता है विदाउट ए एंड बी? यस, द रूल इज दैट अगर एक पार्टनर डिस्चार्ज दे सकता है, ओके, वन पार्टनर कैन डिस्चार्ज, ओके, इन दैट केस if it is of a nature where all of them are under disability या फिर one of them is under disability and another person can institute a suit, then limitation period shall run from the time जब एक भी पार्टनर का डिसेबिलिटी एंड होता है, if he can continue the suit alone without his two partners. But if it is like that there should be all the partners are needed, right? Yeah, all co-heirs are needed. In that case एक भी पर्सन अगर डिसेबल्ड है तो टाइम विल स्टॉप रनिंग, ओके, टाइम विल बी, the time clock will stop for that time. So if one of the several persons are jointly entitled to institute a suit or to make an application, but they are under, one of them is under disability and it is possible that he can give a discharge without concurrence of the other people, then time will run against them all. तो अगर एक भी person is good, in a good condition, he is competent to institute the suit, then time will start against them all. बाद में अगर आप आकर बोलोगे अरे I was तो minor या फिर I was insane at that time, तो कोर्ट विल से तो क्या हुआ, आपका दूसरा पार्टनर तो था ना, वो तो कर सकता था. सो टाइम वाज रनिंग अगेंस्ट यू ऑल, इवन इफ यू वर डिसेबल्ड. बट अगर डिस्चार्ज ऐसा है या नेचर ऑफ सूट ऐसा है दैट ऑल द पीपल आर नीडेड, द कॉन्करेंस ऑफ ऑल द डिसेबल्ड पर्सन इज नीडेड, then time will not run against any of them, not even against the person who is competent, because sabka concurrence is important. So time is going to run in two circumstances. Okay, first is when one of them is capable of giving a discharge without the concurrence of other, and if the disability has ceased to exist. Now, Section 8 talks about the special exceptions. Special exception. It says nothing in Section 6 or in 7 applies to suit to enforce right of preemption or shall be deemed to extend for more than 3 years from the cessation of disability or the death of person affected thereby, the period of limitation for any suit or application. There is a special exception, and what is that? See, you have to note this down in Section 8. कि सेक्शन 6 and section 7 जो है, they are subject to provision of section 8. This is important to note down. Section 6 and section 7 are subjected to section 8, and section 8 is saying that section 6 and section 7 is not applicable to suits to enforce right of preemption. Right, and second thing which it says is that the period can be extended only to a period of 3 years. So what does it mean? What does section 8 mean, students? What is it saying? Section 6 and 7 is my subject to section 8. ठीक है, and यहाँ पर क्या बोल रहा है? What is the next part? It will not be deemed to extend for more than 3 years from cessation of disability or death of person affected thereby. What does it mean? आप एक बात सोचो कि सोचो you are a minor right now. ठीक है, you are a minor right now and you are disabled, legally disabled, so you cannot institute a suit. ठीक है, fine. Now you attain majority when you are 18 years. So section 6 says that आप जैसे ही आपका disability cease होता है, period of limitation will start running and you will get the time period. But सोचो time period is 30 years. अगर limitation period is 30 years, but ये section क्या बोल रहा है? That in no case the provision of 6 and 7 shall not be deemed to extend for more than 3 years after the disability has ceased. Right? So after that point of time, you only get a period of 3 years. This is what section 8 says. Right? So this is a special exception. So you are getting the chance to, start your suit after your disability has ceased, as you might have been allowed when you were, जैसे आप अलाउ होते अगर सब कुछ सही होता. But in no case the period will extend to anything beyond 3 years from the cessation of disability. So after cessation of disability, it will not go beyond 3 years. It will be within 3 years only. Okay. Hope this is clear to everyone. Section 8. This is a special exception, and section 6 and 7 are subjected to this. Now section 9, again very important, continuous running of time. यहाँ पर ये बोला जा रहा है that once your suit has started, okay, once your time period has started, it will not stop. So once the clock starts running, it will be running continuously. It is not going to stop. एक बार आपका टाइम स्टार्ट हो गया टू रन, नो सब्सिक्वेंट डिसेबिलिटी और इनेबिलिटी विल इंस्टीट्यूट अ सूट और मेक एन एप्लीकेशन विल स्टॉप इट. राइट? सो सेक्शन 9, व्हाट डज सेक्शन 9 से, students? It talks about continuous running of time. Section 9 is talking of what? Continuous running of time. And it says that once the time has commenced to operate, it is not going to cease. ओके, इट विल कंटिन्यू रनिंग. अब इसके बाद आप डिसेबल्ड हो जाओ, आप इंसेन हो जाओ, आप इनेबल हो जाओ, यू आर नॉट एबल टू, बट टाइम विल नॉट स्टॉप. वंस इट हैज स्टार्टेड द क्लॉक विल run. Okay, it will not stop. So this is section 9, continuous running of time. Once the disability has ceased to exist and your time clock has started running, फिर बाद में आप वापस इंसेन हो गए, no, then that time will not stop, it will continue to run. ठीक है. But there is also a proviso where letters of administration to state of creditor have been granted to his debtor. The running of period of limitation for a suit to recover debt will be suspended while the administration continues. So, agar a debtor has been given the administration of state of a creditor. Coincidentally, I am your debtor, and I am also given the administration of state of the creditor. So, for that period of time, the creditor cannot, the running of the period of limitation for recovering the debt will be suspended. जब तक administration continue कर रहा है, creditor cannot recover his, that, the period of limitation to recover his debt, that can be suspended. So the creditor will get a chance that he can wait until the administration is continuing. Okay, and he can also file a suit afterward. Right. Come to section 10. Now, section 10 is suit against trustees and their representatives. Again, important. Now, what does this section 10 say? अगर आप सेक्शन 10 देखो तो यहाँ ये बताया जा रहा है कि अगर हमने एक ट्रस्ट क्रिएट किया है फॉर ए स्पेसिफिक पर्पस या फॉर एन ऑब्जेक्ट, हमने क्या करा, एक ट्रस्ट क्रिएट किया है और प्रॉपर्टी किस में वेस्टेड हो गया, इन द ट्रस्टी, राइट. In that case, the beneficiary may bring a suit against the trustee at any time and there is no bar of limitation. So section 10 अगर आप देखो तो यहाँ पर beneficiary has not, like, there is no period of limitation for a beneficiary. No period of limitation has been prescribed to a beneficiary, right? So say for example, I have created a trust for a charitable purpose and I have made अंजना द ट्रस्टी, मैंने अंजना को ट्रस्टी बनाया है एंड आई हैव क्रिएटेड दिस ट्रस्ट. ठीक है. एंड आई टोल्ड अंजना दैट अंजना प्लीज look after this and use it for this charitable purpose. ठीक है. Now Anjana has taken no steps to carry out the purpose, to carry out the trust, and it has been a long time, like 12 years हो चुका है, 20 years हो चुका है. Meanwhile, the person who created the trust has also died, right? And it is being seen that Anjana is taking no steps to do those things for which the property was given to her, right? I, like, the person who created the trust died. After 30-40 years, the person who created the trust, his son comes and he files a suit against Anjana. Okay, that he wants to file a suit against Anjana that redeliver my property to me. It was given to you by my father or by my mother, right? So redeliver it to me because you are not using it for the purpose for which it was created. So will it be barred by limitation? Will the suit be barred by limitation? Section 10 says no. Section 10 says no. Notwithstanding anything contained in this section, no suit against a person on whom the property has been vested in trust for any specific purpose or against his legal representative or assignees for the purposes of following in his or their hands such property or the proceeds thereof, or this shall be barred by any length of time. And what is the explanation saying? The explanation says, for the purpose of this section, any property which is comprised in a Hindu, Muslim, or Buddhist religious or charitable endowment will be deemed to be property vested in trust for a specific purpose, and manager of property will be deemed to be trustee. अब आप बताओ क्या समझ में आ रहा है? सेक्शन 10 में क्या समझ में आ रहा है? एक बार रीड सेक्शन 10. इट्स वेरी इजी. Just read. I'll just drink water. You people can also drink water if you want to. Take a minute. Read the section 10 and tell me what is it saying. So section 10 is saying that if a property is being vested in a trustee, right, and that too for a specific purpose, what is happening here? The property is being vested in a trust for a स्पेसिफिक पर्पस फॉर अ चैरिटेबल पर्पस, और वो पर्पस हमने कैरी ऑन नहीं करा है, या ट्रस्टी जो है वो फ्रॉडुलेंट है, वो पैसे को लेकर मिस अप्रोप्रिएट कर रहा है और सारे पैसे अपने पॉकेट्स में डाल रहा है, तो एंड यू नो a long time has elapsed, 20 years or 40 years हो चुका है. Now if I institute a suit against him, the trustee will say that it is barred by limitation, but section 10 says no. So section 10 is actually saving the beneficiaries from an apparently fraudulent trustee who is putting the trust money in his pocket. So just because the time has elapsed, he cannot uh, escape the litigation, right? तो पहली चीज तो ये है कि एक ट्रस्ट होना चाहिए, और वो एक्सप्रेस ट्रस्ट होना चाहिए, मतलब देयर शुड बी clear thing that the owner of the property wants to create a trust, okay, for discharging some specific purpose. Now this is not applicable to implied trust or to constructive trust. This section does not apply to implied or constructive trust, it only applies to express trust. And the trust is created for a specific purpose. ठीक है, हमने एक पर्पस भी दे दिया है, प्रॉपर्टी को हमने वेस्ट भी कर दिया है इन अ ट्रस्टी, या मे बी आफ्टर हिज ट्रस्टी आई हैव टोल्ड दैट हिज लीगल रिप्रेजेंटेटिव्स और हिज assignees will continue, right? Now this section is applicable against that trustee or that legal representative or that assignee, right, against whom I want to file a suit for some purpose which the court will recognize as just, like say for example he's fraudulent or he's not carrying on the purpose, right? In that case section 10 will be applicable and there will be no bar of limitation. Now it will not apply to executor or partner, agent or director of company because they are not trustees. It will not apply to assignees for value also, because it clearly mentions assignees for valuable consider for not being assignees for valuable consideration. So if there are assignees for valuable consideration, this section is not applicable to that, to them also. एंड द सूट मस्ट बी कि हमें फॉलो करना है ट्रस्ट प्रॉपर्टी को या उनके प्रोसीड्स को, या फॉर द अकाउंट ऑफ द प्रॉपर्टी जो हमने ट्रस्टी को दिया है, राइट? सो आई वांट टू इंस्टीट्यूट अ सूट जस्ट टू सी दैट the trustee is carrying on my purpose, or the trustee is making good use of the money which is coming out from the right, coming out from the property, right? So in that cases, this section says that there is no such limitation period and you can institute your suit anytime, okay, there is no limitation period. Now one thing which it says here, the explanation says, for the purpose of this section, any property which is comprised in a Hindu, Muslim, or Buddhist religious or charitable endowment will be deemed to be property vested in trust for a specific purpose, and manager will be deemed to be the trustee thereof. So the question of Anjana is, will it be applicable to work property? Yes, है ना? Because यहाँ Muslims, Hindu, and um, Buddhist religious and charitable endowments are also deemed to be property with vested in trust, और उनके मैनेजर्स जैसे कि वक्फ प्रॉपर्टी में इट इज मुतवल्ली, they are also deemed to be trustee. So section 10 is also applicable to them. Clear, Anjana? Clear? Come to section 11. Suits on contracts entered into outside the territory to which this act extends, right? So if you see this section, section 11, now here आपको समझ में आ जाएगा ना कि whether limitation act is lex fori और lex loci, है ना? ये हमें समझ में आता है सेक्शन 11 देखकर. तो जब हम सेक्शन 11 देखते हैं, हमें दिखेगा that suits which are instituted in India, ठीक है, on contracts, entered into a foreign country are subject, अगर आप सेक्शन 11 पढ़ो, they are subject to the rule of limitation contained in the act, and no foreign rule of limitation will be defense to suit, है ना, instituted in India, unless the rule has extinguished the contract या फिर the parties are domiciled in foreign country during the period prescribed by such rule. Now see, if you see section 11, you will find that general rule क्या है international law का. What is the general rule of international law? That a contract with reference to, जो भी contract है वो governed होता है by lex loci contractors, मतलब law of the place जहाँ contract is made. लेकिन procedures क्या है? Procedures are governed by lex fori, means law of the country जहाँ पे आप suit, जहाँ पे action आप लेना चाहते हो. Now limitation जो है that is governed by lex fori, because questions of limitations are matters of procedure, है ना. तो हमारा limitation act is lex fori. अगर आप सेक्शन 11 का क्लॉज 1 देखोगे, it says suits instituted in territories to which act extend on contract entered into in state of Jammu and Kashmir or in a foreign country will be subject to rules of limitation. इसका क्या मतलब है कि हम लिमिटेशन एक्ट के थ्रू ही जाएंगे, एंड लिमिटेशन एक्ट इज लेक्स फॉर, दैट मींस wherever you institute your suit it will be governed by that place का limitation act only. And 11 clause 2 says that it is following the English common law, according to which foreign law of limitation will be preferred to lex fori on दो condition में ही ये preferred होगा. when, what are the two condition? If the rule has extinguished the contract, or the parties were domiciled in the state or in a foreign country during the period when this rule was there. तो अगर एक सूट इंस्टीट्यूट हो रहा है in a territory जहाँ पे limitation act is applying, then the rule of limitation act 1963 will be applicable. ठीक है. And one exception is that it will not apply to rules of limitation in a foreign country if if these two conditions are met. So no foreign rule of limitation will be defense to a suit if it is instituted in India or on a contract entered into a foreign country, unless the rule has extinguished the contract or the parties were domiciled in a foreign country during that period of time. ठीक है. तो ये हमारा पार्ट 1, पार्ट 2 we have completed. Part 1 was section 1 and 2, part 2 was from section 3 to 9. अब आप देखो, we have part 3 which is computation of period of limitation, and it is from section 12 till 24, right? So यहाँ पे पूरा प्रोसीडियर इज गिवन कि आप किस तरीके से टाइम पीरियड को कैलकुलेट करते हो अंडर लिमिटेशन एक्ट. तो पार्ट 3 जो है कंप्यूटेशन ऑफ पीरियड ऑफ लिमिटेशन जो है, उस पे हमें समझ आता है कि व्हाट इज द मेथड फॉर कैलकुलेटिंग द पीरियड ऑफ लिमिटेशन. सो सेक्शन 12, 13, 14 if you see, section 12, 13 and 14 if you see, section 12 talks about exclusion of time in legal proceedings. सेक्शन 13 टॉक्स अबाउट कहां पर टाइम एक्सक्लूड होगा, जहां पे लीव टू सू और अपील एज अ पॉपर इज अप्लाइड फॉर, राइट. सेक्शन 13 जहां पे लीव टू सू और यू आर अपीलिंग एज अ पॉपर. देन एक्सक्लूजन ऑफ टाइम ऑफ प्रोसीडिंग बोनाफाइड इन कोर्ट विदाउट जुरिसडिक्शन. एक्सक्लूजन ऑफ टाइम इन अदर केसेस, यहाँ पे कुछ अदर केसेस है जहां पे हम टाइम एक्सक्लूड कर सकते हैं. व्हाट इज द इफेक्ट ऑफ डेथ on or before the accrual of right to sue? What is the effect of fraud or mistake under section 17, right? What is the effect of payment on account of debt or interest on legacy? 19. Effect of acknowledgement is section 20. 21 is effect of substitution if you are adding a new plaintiff or defendant. 22 is continuing breaches and tort. 23 is suits for compensation, and 24 is computation of time mentioned in instrument. Now if you see 12 talks about exclusion of time in legal proceedings. कौन कौन सा टाइम को हम एक्सक्लूड कर सकते हैं इन आर लीगल प्रोसीडिंग. सो इफ यू सी सेक्शन 12 यू विल सी दैट 12 क्लॉज 1 बोलता है कि एनी सूट, अपील और एप्लीकेशन. सो इट अप्लाइज टू सेक्शन 12 क्लॉज 1 इज अप्लाइंग टू सूट, अपील एंड एप्लीकेशन. ठीक है. तो it says that in computing the period of limitation for this, the day from which the period is to be reckoned shall be excluded. So say for example, if my suit is to, like, my limitation period is starting from say it's starting from 1st January. So यहाँ पे बोलता है कि 1st January will be excluded. और ये सूट अपील एप्लीकेशन के केस में, if it's for, if it is for, an appeal or application for leave to appeal for revision or review for judgment, then the day on which the judgment is pronounced and the time which is required for obtaining the copy of the decree, right, or the order, that will also be excluded. And if the application is to set aside an award, 12 clause 4 says, if the application is to set aside an award, the time which is required for obtaining a copy of the award will be excluded, right? So these are exclusion of time in legal proceeding, right? An explanation says, in computing under this section, the time required for obtaining a copy of decree or an order, any time taken by court to prepare the decree or order is, right, the time which is taken by court to prepare the decree or order before an application for copy is made shall not be excluded. तो आपको बहुत जल्द प्रॉम्प्टली काम करना है. हम कोर्ट ने सोचो डिग्री या ऑर्डर पास कर दिया है और अभी तक यू हैव नॉट अप्लाइड फॉर योर जजमेंट कॉपी एंड फॉर योर डिग्री का कॉपी, और बाद में आप आकर बोलते हो कि कोर्ट ने तो इतना टाइम ले लिया. नहीं, जब तक आप अप्लाई नहीं करोगे, दैट पीरियड विल बी इंक्लूडेड. ओके, बिकॉज you are delaying it from your side, so we will not exclude that time period. That will, we will include it कि आपने इतना देर करा, right? लेकिन जितना period court लेगा for preparing the decree or judgment, that is excluded under section 12 explanation. Hope 12 is clear. 13 is very easy. It says that if it's a pauper suit, ठीक है, अगर एक pauper उसे forma pauperis में करना चाहता है, like he wants to apply as a, he wants to continue as a pauper, तो he will give his application to that, I cannot pay the court fees and all that. So the time during which the application in forma pauperis is being continued will be excluded, and if that is bona fide, it will be excluded, right? So if you are applying to the court that you want to you want to continue as a pauper, so in computing the period of limitation, if the application for leave to sue or appeal as a pauper is made and is rejected, or आपने करा और reject हो गया, then the time during which the applicant has been prosecuting in good faith will be excluded, and the court will, for the payment of court fees prescribed for such court, treat the suit or appeal as having the same force and effect as if the court fees has been paid in the first instance. So that time period for which he is, भले ही वो रिजेक्ट हो गया, अगर एक्सेप्ट हो गया तो वेरी गुड, बट अगर रिजेक्ट हो जाता है तो इसका मतलब ये नहीं कि हम उस टाइम पीरियड को गिनेंगे नहीं. इफ यू आर प्रोसिक्यूटिंग इन गुड फेथ, इफ यू आर कंटिन्यूइंग इन गुड फेथ, एंड दैट टाइम पीरियड इज आल्सो excluded by the court. Okay. 14 आ जाओ, exclusion of time of proceeding bona fide in court without jurisdiction. So if I have been continuing in a court and I didn't knew that this court does not have jurisdiction, I am continuing in good faith, right? So if I am prosecuting in a court with due diligence, but in a court which is like of not my jurisdiction, right, तो उस टाइम पीरियड को एक्सक्लूड कर दिया जाएगा, the time period for which you have been proceeding in good faith. So the time during which you are prosecuting with due diligence, but whether in a court of first instance or appeal or revision, that is going to be excluded. ठीक है? If there was a defect of jurisdiction, so let's talk about defect of jurisdiction. Then come to सेक्शन 15 में और भी काफी सारे पॉइंट्स दिए हैं जहां पे आप जुरिस्डिक्शन को एक्सक्लूड कर सकते हो, राइट? In many other cases where you can exclude your jurisdiction. So I'm not going through this, just go through a reading, it's easy. Now 16 is important, effect of death on or before the accrual of right to sue, right? Now what is the effect of death? What does section 16 say, students? If you see section 16, what is it saying? Yes. So say for example, if a person है ना, he has died, he is dead, but आप मान लो कि अगर वो लिविंग होता, ओके, सो इफ अ पर्सन who is died, but अगर मानते हैं, अगर अगर प्रिज्यूम करते हैं he was living and he would have had the right to institute a suit or to make an application, but he dies before that right is coming to him, he dies, या फिर that right comes only after his death. In that case, section 16 says the time when there is a legal representative of the deceased capable of instituting the suit or making such an application. Okay. So if a person would have got that right if he was living, or if he got that right after his death, then the period of limitation will be computed from the time when there is a legal representative of the deceased who is capable of instituting such suit. So just because he's died, he's dead, उसका limitation period या उसके rights खत्म नहीं हो जाते, वो rights will pass on to his legal representative, and when the legal representative is fit and capable of instituting the suit, then he will get that right to institute. Okay, then from that period we are going to compute it. And if the person is living, or if the right has come to him after the death, ठीक है, and it's relating to, you see, if he were living, a right to institute a suit or make an application would have accrued dies. अब देखो ये दोनों में ही आपको सेम चीजें दिखेगी, आपको लगेगा कि मैम ये दोनों ही तो सेम है, बट आप एक बात बताओ कि सेक्शन 16 में आपको क्या डिफरेंस दिख रहा है क्लॉज 1 में और क्लॉज 2 में? टेल मी, व्हाट इज द डिफरेंस बिटवीन क्लॉज 1 एंड क्लॉज 2? इफ यू सी क्लॉज 1, राइट, what do you see? You have a right to institute a suit, right to institute, ठीक है, एंड यहाँ पर क्या है, यहाँ पर जो है ये अगेंस्ट एनी पर्सन है. That means this clause is applicable to plaintiff and this clause is applicable to defendant. This is, otherwise if you read everything is same, but यहाँ पे against word use नहीं है clause 1 में, clause 2 में against word है. That means section 16 is applying to plaintiff and section 16 clause 2 is applying to my defendant, and section 3 section 16 clause 3 is a exception. What does the exception say? Nothing in subclause 1 or 2 will apply to suit to enforce right of preemption or to suit for possession of immovable property or a hereditary office. So if a person has died, ये preemption में apply नहीं करेगा. Okay. So this provision is not applicable to suits to enforce right of preemption. Suits to enforce right of preemption. The second, it will not apply to suits for possession of immovable property or suits of hereditary office. It is not going to apply in these cases. Section 17 पे आओ, right, plaintiff and defendant right. Section 17 is regarding my very important effect of fraud or mistake. Now say for example someone has committed fraud on you, okay, he did fraud but you did not know of this fraud, आपको बाद में पता चला, maybe I committed a fraud on you, I gave you a phone which is not iPhone, it's a copy of iPhone, बट उसमें आईफोन का प्रॉपर मैंने लोगो एंड ऑल लगाकर आपको बेचा और आपको लगा कि ये आईफोन है और आपने उसी दाम में खरीदा है मेरे से. After 5 years, like after the period of limitation is over, you get to know that this iPhone, when you go to the company for some service, you go to the main service center of iPhone, and they say this is a duplicate copy, this is not original, so we cannot service this. And then you realize that I committed fraud on you and I have taken complete like 1 lakh or 1,70,000 rupees, the same price which is for the iPhone. लेकिन limitation period तो over हो गया. So what is the remedy? What is the remedy? This says, this section 17 says that if you want to institute a suit which is based upon fraud of the defendant or the respondent or his agent, right, or the knowledge of the right or title on which a suit or application is founded but is concealed by fraud, or if it is from consequences of mistake, or if in case a document which is necessary to establish the right of plaintiff or application has been fraudulently concealed. In that case, when will the period of limitation begin? It will begin only when the plaintiff and applicant has discovered the fraud or mistake, or could with reasonable diligence have discovered it, or in case of concealed document until the plaintiff or applicant had the means of producing the concealed document or compelling its production. So just because it's been a long time, लेकिन fraud तो मैंने बाद में discover करा, right? Fraud मैंने बाद में discover करा, या ये mistake मैंने बाद में discover करा है. In that case, your period of limitation will only start after you have discovered that fraud or that mistake or that concealment. ठीक है? Is this clear? So if someone has, actively concealed also one fact from you, in that case also you can only the period of limitation will start when you have the means of producing that document in the court of law. तो पहले आप प्रोड्यूस नहीं कर पा रहे थे इसलिए आपने केस नहीं करा, लेकिन बाद में अगर आप प्रोड्यूस कर सकते हो, जब द मोमेंट यू आर अंडर द you are in possession of those documents, you can institute it. So section 17 talks about effect of fraud and mistake. Section 18, if you see, it is talking about effect of acknowledgement. आप जितनी बार acknowledge करोगे उतना ही बार limitation period, fresh period of limitation will start. Okay, as many times as you acknowledge, as many times the period of limitation will start. So say for example, मैंने आपसे एक debt लिया है and I have taken that debt in 2021 and the time period for recovering the debt is 3 years. तो आपके पास time period है 2022, 2023, 2024 के end तक you have time to recover the debt. इसके बाद आपको नहीं मिलेगा. But in 2023, I tell you that, see, I have got this debt, but I will pay you later. I am unable to pay it now. I'll pay it to you. The moment I acknowledge the fact that I am your debtor, a fresh period will start. So जो ये time period था 24, this will extend again. 2023 को अगर वापस मैंने acknowledge करा है तो fresh period of limitation will again start. आपको वापस 3 years मिल जाएगा. मेरे acknowledgement से आपको वापस से 3 years का time मिल जाता है, right? So if before the expiration of the period of time period is just about to expire and you come and tell me कि ma'am I am going to institute a suit against you because मेरा time period भी expire हो रहा है और आप अभी तक पैसा भी नहीं दे रहे हो, तो I tell you अच्छा ठीक है, I am acknowledging that I will give it to you after some time. Don't institute a suit right now. I am acknowledging a fresh acknowledgement that I owe you this much money. So the acknowledgement will have the effect of a fresh limitation period, and the moment I acknowledge it, आपको वापस से 3 years fresh limitation period उस दिन से start हो जाएगा. Okay, this is the effect of acknowledgement. Same with section 19, effect of payment on account of debt or interest or of interest on legacy. So this is also, just go through section 19. I'm not going through it. Okay, because I want to. Section 20 is also regarding acknowledgement. 21 पे आ जाओ. What is the effect of substituting or adding new plaintiff or defendant, students? अगर हम न्यू प्लेंटिफ या डिफेंडेंट को सब्स्टिट्यूट करते हैं तो क्या होता है? यस, सेक्शन 21 पर आ जाओ. सब्स्टिट्यूटिंग न्यू प्लेंटिफ एंड डिफेंडेंट, व्हाट विल बी द थिंग, व्हाट विल बी द इफेक्ट? Anyone who can tell me the effect? We are about to complete, don't worry. We will just give me more half an hour, we will complete this. Okay, what will be the effect of substituting or adding new plaintiff and defendant? See, where after the institution of a suit a new plaintiff or defendant is substituted, the suit as regard him will be deemed to have been instituted when he was so made a party. तो अगर हम एक हमारा सूट ऑलरेडी ऑनगोइंग था लेकिन हमने एक नया प्लेंटिफ या नया डिफेंडेंट को सब्स्टिट्यूट किया या ऐड किया है, तो सूट शैल एज रिगार्ड हिम विल बी डीम्ड टू हैव बीन इंस्टीट्यूटेड on the day when he is made a party, provided if the court is satisfied that if the omission to include him as a new plaintiff or defendant was due to mistake made in good faith, it may direct that the suit as regards such plaintiff or defendant shall be deemed to have been instituted on any earlier day. And nothing in this subsection will apply to a case where a party is added or substituted owing to assignment or devolution of interest during pendency of a suit, or where a plaintiff is made a defendant or defendant is made a plaintiff. So if you see order 1 and rule 10 of CPC, ठीक है, ऑर्डर 1 रूल 10 अगर आप देखो ऑफ सीपीसी, दैट प्रोवाइड्स फॉर स्ट्राइकिंग आउट, एडिशन, सब्स्टिट्यूशन ऑफ पार्टीज। ऑर्डर 1 रूल 10 में हम देखते हैं, है ना, वहां पे एडिशन, सब्स्टिट्यूशन सारी चीजों से चीजें लिखी हैं। नाउ हियर सेक्शन 21 सेज दैट से फॉर एग्जांपल इन अ केस, अब क्या होता है कि ऑर्डर 10 रूल 1 क्या, ऑर्डर 1 रूल 10 के अंदर क्या होता है, these orders can be passed with respect to plaintiff in course of like if the plaintiff has not been added or किसी तरीके से misjoinder हो गया या कोई wrong plaintiff add up हो गया, so such orders can be passed in cases of misjoinder or non-joinder of any plaintiff or defendant. Problem is arising uh, if the original suit is already filed, हमने original suit बहुत पहले फाइल करा है, and it may happen कि addition या substitution is taking place after the time period has elapsed. तो 1st February was my last date to file the suit. मैंने 1st January को ही फाइल कर दिया अपना सूट, मैंने 1st January को ही फाइल करा है, बट प्लेंटिफ को मैंने ऐड करा है आफ्टर 1st February, that means on 10th February I have added. Then what will happen? So if a party is added or substituted after the limitation period, after the prescribed period for suit has elapsed, in such cases the bar of limitation would apply या फिर will not apply. So in some cases bar of limitation applies and a new addition, new substitution cannot be done. But if you see 21 clause 1, it says that the party will be deemed to have been substituted or added when he was made a party. So that means on the date when he is made, that means on 5th February, even after the date has elapsed, he will still be deemed to be a party. But in any case, if the party is added or substituted after prescribed period for after the suit has expired, bar of limitation is applicable and the suit shall not be entertained. So if you see the general effect of 21 clause 1, you will see that the party shall be deemed to have been substituted or added when he was made a party, and the general effect of 21 clause 1 yahi hai. Otherwise it will be deemed that he cannot be added because of lapse of time, right? So this is section 21 and it is not applicable to appeal. Come to 22, continuing breaches and tort. Agar socho, section 22 is talking about multiplicity of suit because there is not a single action, lot of actions are going on. There is a continuing breach of contract or there is a continuing tort going on. In that case, fresh period of limitation will begin to run every time when the breach of contract is made or the tort is committed as the case may be. तो आज मैंने आपके घर के सामने एक न्यूसेंस करा है, ठीक है, I'm doing some nuisance in front of your house, right? So a tort is continuing, second day also I'm doing, third day also I'm doing. In that case the cause of action will be renewed day to day, ठीक है, और हमको क्या मिलेगा, हमको एक fresh period of limitation will begin to run every moment that tort is committed or that breach of contract is done. Come to 23, suit for compensation for act not actionable without special damage. So in cases of suit for compensation जहाँ पे एक specific injury है या आपको एक special damage मिलेगा, the period of limitation will be computed from the time when the injury results, right? So here it is talking about the compensation. Ordinary case में क्या होता है, time usually run कब करता है, from the commission when the wrong was done. But for example रॉन्ग आपने आज करा है लेकिन इसका इफेक्ट मेरे को बाद में हुआ है, ठीक है. सो section 23 says that in case of suit for compensation for act which does not give rise to any cause of action unless some specific injury is resulting, period of limitation will be computed from the time only when the injury is resulting. So if the cause of action is there, right, but I have not suffered any injury, then no time period will run, will be running. So in case of suit for compensation, जहाँ पे कोई cause of action नहीं है unless specific injury is resulting, period of limitation is to be computed from the time when the injury is will come, right, जब result करता है. तो so say for example A and B have adjoining lines. ठीक है, ए एंड बी का प्रॉपर्टी जो है बिल्कुल एडजेसेंट है, दे हैव एडजॉइनिंग लैंड्स, एंड बी के लैंड में एक ट्री है विच इज पॉइजनस, which overhangs in the land of A, right? It is overhanging in the land of A. Now this act of the tree overhanging in the land of A is not a result because इससे कोई लॉस नहीं हो रहा है to A, but negligence will be said to commence the moment the branch is allowed to overhang. Let's say now after 2-3 months of such overhanging, A का जो horse है वो उस poisonous tree से कुछ fruits खाता है and he dies. Now A has the A has the time period for A starts running and he can file his suit. So unless and until some specific injury is resulting, you cannot file your suit for compensation. ठीक है, एंड 24 इज कॉम्प्यूटेशन ऑफ टाइम मेंशन इन इंस्ट्रूमेंट. अब देखो यहाँ पे ये सिंपली ये बोलता है दैट फॉर द पर्पस ऑफ लिमिटेशन एक्ट हम कौन सा कैलेंडर यूज करेंगे, वी विल यूज ग्रेगोरियन कैलेंडर. वेरी इंपॉर्टेंट. ओके, ये भी आता है इन एमसीक्यूज दैट कौन से कैलेंडर को आप यूज करते हो, इंग्लिश कैलेंडर यूज करते हो या फिर आप कोई पर्सनल कैलेंडर यूज करते हो अपने. देर आर बंगाली कैलेंडर्स, देर आर English calendars, there are Islamic calendars. So for the purpose of limitation act, section 24 says that we are going to use Gregorian calendar. ठीक है, Gregorian calendar is British calendar which was introduced by Pope Gregor 13, ठीक है, in 1582. So for the purpose of this act we are going to use Gregorian calendar. So this part is completed. अब जो important part है which is part 4, which is acquisition of ownership by possession. Very important, and इसमें I won't be taking ज़्यादा time. You all already know, but this is an important portion, so I just need to tell you what is here. Okay, now if you see section 25, you will see that यहाँ पर है acquisition of easement by prescription. Prescription and easement के बारे में हम बात कर रहे हैं. So it says that अगर आप कोई you have an access to use of light or to air, right, and you are using that part, light or air or something, peaceably without any interruption. In that case it says that you get a right to easement due to prescription. So you are acquiring easement by prescription under section 25. Very important. Acquisition of easement by prescription. Okay, what does it say? That if you are having access and use of light or air, पहली चीज आप देखो, if you have access and use of light or air and that is you are using peaceably for a period of 20 years, यहाँ पे period भी mention, अगर आप 20 years तक इस light and air को आप आराम से बिना किसी interruption के peaceably if you are using for a period of 20 years, or if you have a right to a way or water course, right to way or water course, and you are also again enjoying this peaceably and openly without any claim from anyone, again for a period of 20 years. The period here mentioned is 20 years. Then the right to this light or air or this way or waterway will become absolute and will become indivisible. Now it cannot be defeated. Now this right cannot be defeated. So each of this period of 20 years is going to be taken. Okay, and this should be peaceably enjoyed and openly enjoyed. You have to enjoy it peaceably, you have to enjoy it openly, and you are enjoying it as a matter of right. If you have got it for more than 20 years peaceably, if you are enjoying it for more than 20 years, you are getting the right to, now no one can remove you from using this light or from accessing this water or from accessing this way. This is 25. 26 says exclusion in favor of reversion or of servient tenement. Now again this section talks about what it if there is a servient heritage, you know about servient heritage and you know about dominant heritage, है ना. तो section 26 जो है वो बोलता है that section 26 is saying that the time during which for instance हम लोग एक चीज मान लेते हैं कि A is suing B for a declaration that he is entitled to a right of way over B's land. So A is claiming that I have a right of way over your land, and A is also proving that he has enjoyed it for 25 years. But B अगर ये शो कर दे कि during that period of 25 years उसने 10 years तक अपना land एक has he had given to a tenant or he had leased it, he had leased it, then in that case those 10 years will be excluded and it will be supposed that A was only using it for 15 years and not 25, क्योंकि 10 years तक क्या है, 10 years तक he had actually given it to someone else and the owner was not using the property, he had leased it, or during that period someone was else was having a life interest in that land, right? So if a servient heritage is not in possession of the servient owner but it is under a lease, and that too for a term exceeding 3 years, or if it's subjected to a interest for life, देखो यहाँ पे लिखा हुआ है, if it is under lease for a term of 3 years, okay, during which it is being granted, or say for example if it is given for lease or interest is continued, in that case that period will be excluded from computing the requisite period of easementary right. Is this clear to everyone? Section 26, 25 and 27 is most important, extinguishment of right to property. Now देखो general principle of limitation act is that limitation will bar the remedy but will not extinguish the right, but section 27 actually extinguishes the right. It says that if a person is sleeping for a period, okay, after a certain amount of time his right is going to be extinguished regarding any immovable property. If say for example um, if a time period has elapsed, then your title ceases to exist in the property. So section 27 is my exception to my general principle. Limitation bars the remedy but does not extinguish the right or does not extinguish the title. लेकिन section 21 क्या कर रहा है? Extinguishment of right to property. So it is extinguishing the right also and it is also extinguishing the title of the person. And when will it be extinguished? If it is a suit for possession of property and the property is adversely in possession of another person for 12 years. So for a period of 12 years, if someone else is having an adverse possession of the property, he becomes the adverse owner, and now you cannot claim your title to the property, and the suit for possession is also barred by limitation act. So in this cases your right also extinguishes and your remedy also gets barred, right? But the defendant should be in actual possession of the property and he must be using it openly and adversely, okay, and for a period of 12 years minimum. So this is 27. 28 I'm not going 28 is repealed. 29 is the saving provision. 30 talks about provision for suits जहाँ पे prescribed period is shorter than the period prescribed in Indian Limitation Act 1908. तो यहाँ पे दो चीजों की कंपैरिजन करी गई है कि अगर लिमिटेशन, now we are just about to finish students, okay, so just be a little patient, बस हो गया. आर्टिकल अगर आप सेक्शन 30 देख लो तो आपको मिल जाएगा that section 30 talks about you know if it is comparing 1908 का and 1963 का act. So what will happen अगर 1908 के एक्ट में uh, the prescribed period was longer एंड यहाँ पे हमने शॉर्टर प्रिस्क्राइब करा है, तो उस केस में क्या रेमेडी है, क्या करना है, क्या क्या रूल है, वो दिया है सेक्शन 13 में, राइट. सो आई एम नॉट गोइंग इनटू द डिटेल्स. एंड then you have your schedule, which is, as I told you, there are three divisions. The first division is suit, the second division is appeal, the third division is application. First division suit is divided into 10 parts, second division is not divided into any part, and third division is divided again into two parts. And I have also given you the importance of in the starting only कि कौन से articles important है for your exam and कौन से sections important है. So hope it is done, student. Any doubt from anyone? If you have any doubt, you can just tell me. Any doubt, student? Okay, students. Thank you for your patience. I hope that you all can, give your exams in a very proper way. All the best. Thank you.